Today on Bench Briefs, we're looking at a recent Supreme Court of Canada decision that tackles an important question about police powers and your rights under the Charter. The case is R.V. Hills, decided in early 2023, and it asks when and how police can search your vehicle without a warrant, and what that means for your protection against unreasonable searches. So, what happened in this case? Mr. Hills was pulled over by the police, who then searched his vehicle without getting a warrant first. During that search, they found controlled substances, drugs, and charged him with possession. Hills argued that the search was illegal because the police didn't have a warrant, and that this violated his rights under Section 8 of the Canadian Charter of Rights and Freedoms, which protects people from unreasonable search and seizure. The case made its way up to the Supreme Court because it raised a really important legal question. When is it okay for police to search a vehicle without a warrant, and when does that cross the line into violating someone's charter rights? Also, if the search is found to be unconstitutional, should the evidence they found, the drugs, be excluded from the trial under Section 24(2) of the Charter? That section allows courts to exclude evidence if admitting it would bring the administration of justice into disrepute. At the heart of this case is the balance between two competing interests. On one side, we have the police, who need to be able to investigate crimes efficiently, sometimes without the time to get a warrant. On the other side, there's the individual's right to privacy and protection from arbitrary state intrusion. Cars are a bit of a tricky middle ground because they're mobile, and the law recognizes that sometimes waiting to get a warrant might not be practical. But how far can police go without crossing the line? Before this case, Canadian courts had developed some rules around warrantless vehicle searches, but there wasn't a clear, consistent framework. The Supreme Court in R.V. Hills was asked to clarify how to assess whether such searches are reasonable under the Charter. The court confirmed that, generally speaking, a warrantless search of a vehicle is presumed to be unreasonable unless it falls within a recognized exception. One of the main exceptions is if the police have reasonable grounds to believe that the vehicle contains evidence related to a crime, and that getting a warrant isn't feasible because the vehicle might be moved or evidence destroyed. In Hill's case, the police did not have a warrant, but they argued that the circumstances justified searching the vehicle without one. The Supreme Court closely examined whether those circumstances met the legal standard. Ultimately, the court found that the search was unreasonable because the police did not have sufficient grounds to justify bypassing the warrant requirement. This meant that the search violated Hill's charter rights. Next, the court turned to whether the evidence found during the search should be excluded. This is an important step because excluding evidence can sometimes mean the accused avoids conviction, even if they did commit the offense. The court applied the usual test under Section 24(2), looking at factors like how serious the charter breach was, the impact on the accused's rights, and the overall effect on the justice system's reputation. Given that the police had breached Hill's rights in a serious way by conducting a search without proper grounds, the court decided that admitting the evidence would bring the administration of justice into disrepute. As a result, the drugs found in the vehicle were excluded from the trial. Why does this case matter? R.V. Hills is a key decision because it reinforces the importance of the Charter's protection against unreasonable search and seizure, especially in the context of vehicle searches. It makes clear that police cannot simply search cars whenever they want without a warrant. They must meet strict criteria to justify such searches, and if they don't, the evidence they find can be thrown out. This ruling helps to maintain the balance between effective law enforcement and protecting individual rights. It sends a message that constitutional rights are not just words on paper. They have real consequences when violated. For everyday Canadians, it means that your privacy rights in your vehicle are robust, and police need to play by the rules. Thanks for listening to this episode of Bench Briefs. Be sure to join us next time when we unpack another important legal decision shaping Canadian law. Until then, take care.